Today is December 10th, 2020, and welcome to Mediation, the New Possibilities Hour. This is part of the Will Work for Food project organized by Natalie Armstrong-Motin. There's no charge for these great webinars. Rather, we invite you to contribute to a food bank to help fight food insecurity if you like what you see. And Natalie, we've been doing these since the spring. You started them and were kind enough to invite me to join the team. And I understand we have some very good news to announce this week in terms of our running total of what we've done to fight food insecurity. So would you please share that good news with us?
Absolutely, my pleasure, Jeff. Today happens to be Hanukkah, and as a gift to Will Work for Food, one of our regular attendees made a $1,000 donation to Will Work for Food for us last week, and that put us over the $62,000 raised for food banks worldwide.
Wow. Wow, that is that's awesome and just wonderful. And thanks so much to all those who have attended these programs and supported food banks all over the world, really. And thanks so much to our many speakers who have come and volunteered their time. And Natalie, thanks most of all to you for huge amount of time and passion and energy that you've put in to this incredible project. Hats off, most particularly to you. So now, today we have an interesting topic, mediating liability claims when there is no insurance present. We have one familiar speaker and a brand new speaker to share with you today. Familiar speaker, of course, is Jean Lawler, who's been with us before and is joining the team of the Will Work for Food project. We're so happy to have Jean on board the team. Jean was formerly a very distinguished litigator and managing partner of the law firm of Murchison and Cumming, and last couple of years has become a mediator, Lawler ADR Services, and her practice has taken off like a rocket. It's just been great, and congratulations, Jean. And we're very happy to have you presenting with us and on the Will Work for Food team. And alongside her is Mr. Bryan Weiss, who's up in the San Francisco Bay Area, partner in the law firm of Murchison and Cumming, does complex insurance coverage litigation and other litigation as well. And folks, Bryan and Jean, we give everybody an opportunity to mention a particular food bank that is important to them. We encourage people to contribute to those food banks or others of their choice. So if each of you, Jean first, if you'd like to mention a food bank that's important to you, we'll post it in the chat and encourage people to contribute.
Okay, great. Thanks, Jeff. And hello, everyone. I would say let's go this week, from my perspective, to Homeboy Industries, homeboyindustries.org. Some of you may have heard about it. It just received a huge grant for what it does. It is not only food, but it's helping people get out of gangs and the like. So Homeboy Industries.
Yes, Father Gregory Boyle has done just an incredible job and is one of our leading citizens here in Los Angeles for all the good work he's done for so many years with Homeboy Industries. It's terrific. Bryan, please.
Yeah, up here in the Bay Area, there's an organization called the Alameda County Food Bank. And I sent the website address to Natalie, and she's circulating it. I go there every so often to help stack boxes and cans, and it's amazing how many people they are helping out, and especially during this pandemic. And there's just, when I get there, there's already line around the block, and it's every day, all day, and it's a great organization that's really helping out people in need. So thank you, guys.
Fantastic, fantastic. And now we have the substance of your presentation, Jean and Bryan. So with that, the floor is yours.
Well, great. Thank you. It's a pleasure to be here. So often as a mediator, we get involved in cases where there may be insurance defending an insured and an insurance representative present, but there is either no coverage for certain damages, and coverage for others, or very questionable coverage for the whole thing, and maybe a debt relief action's been filed, and the insurance claims representative is not necessarily providing, there's not necessarily coverage for all of it. So it gets a little bit interesting, and you may end up finding yourself mediating 2 or 3 cases that day in one. You know, you've got the plaintiff, the defendant, the insured defendant, and maybe even more than one insured defendant and its insurers, and then maybe multiple insurers as well, and who pays for what or not. So Bryan, why don't you lead off?
Thank you. So just a brief bit about what I bring to the table here is I've been doing coverage law, insurance coverage law on behalf of carriers since 1993 when Jean grabbed me and took me into her office and said, "Would you like to do insurance coverage?" And I said, "What the heck is that?" And she explained it to me, and like her, mediation practice shot off like a rocket. So did our coverage work together. So it's great to be back with Jean again in this platform. But in any event, since that time, I have been representing carriers, insurance carriers, in not only litigation but mediations. And I'm based. Mediations are challenging enough when there's no coverage component to it, no insurance challenges. But when you add the complexity of an insurance coverage overlay dispute, it makes it even more challenging. Basically, I've gone to hundreds of mediations playing the role of coverage counsel, where my role is to advocate on behalf of the carrier with respect to what's owed and what's not owed, and trying to settle the case. But basically, from your standpoint, I guess I'm the guy you don't want to see walk into the room, because when you see me, it probably triggers a fear in your mind. Okay, this is the guy that is standing in the way between me and settling the case, because he's the one that's going to draw a line in the sand as to what the carrier is going to pay. So I understand that I'm not the most popular guy when I walk into a mediation, but be that as it may, I do have a role to play. And in the next 20 minutes or so, I'm going to try to enlighten you as to how we can work together as mediators and coverage counsel to really accomplish the ultimate goal, which is to get the case settled, or if it doesn't settle, to move it towards that direction, maybe clarify some issues, crystallize some issues, get people kind of working towards a final goal. So even if it doesn't settle that day, at least we've hashed out some of the things. So as Jean said, a lot of you folks may mediate cases where insurance is not an issue. It might be a family law case. It might be a business dispute. Might be a corporate thing. So, we're not worried about that. And there's other cases where the insurance money is what is driving the settlement. It might be a personal injury case. It might be a construction defect thing. But there's no coverage dispute. The carrier, the insurance company, has accepted full coverage, and they're there to settle the case. Now, they're not going to pay the top dollar maybe that the plaintiff wants, but they're there to settle the case. So it's just a binary type of mediation. And then, of course, you have situations where, like Jean said, there are coverage disputes. Now, there may be coverage disputes in a number of different ways. You might have what we call mixed cases, where someone files a complaint and there's a whole hodgepodge, a cafeteria of claims and damages and theories of liability. Some of those are covered, some are not. The typical case might be a construction defect case, where there's always going to be some amount of covered damages and non-covered damages. So I'm there as coverage counsel to advocate my clients, the carrier's position, saying, hey, we'll pay on the covered claims, but we're not going to pay on the non-covered claims. Another example would be something that I am very active in now, which is in the Bay Area, habitability claims. This is where tenants are suing landlords for allowing their apartment buildings to be, for lack of a better term, slumlords type things, where there's massive problems alleged with the building. Now, one of the things I always claim is that there's mold, and most insurance policies, liability insurance policies, exclude coverage for mold. So we get to a mediation, and the plaintiffs are ticking off all their injuries and damages, and then they hit the mold part, and I have to say, sorry, we're not going to pay for that. So how do you, as a mediator, how do you wrangle that? And then there's other situations where the carrier is defending, but it might be a novel issue of law, where they say, yeah, we're going to defend because it's not clear, but we think at the end of the day, a court's going to find there to be no coverage. For example, in this gig worker economy, you have Uber, Lyft, DoorDash, Airbnb, all this stuff, and there's gaps in insurance coverage. So they may be defending the suit, but the carrier is testing a legal theory and saying, we don't think that we owe indemnity coverage. So we're here at the mediation, we'll see if we can settle the case, but we're not going to pay that much because we think we're going to win on the legal issue. So again, as a mediator, what are your challenges there? And then the third situation might be where there's multiple carriers and they're all pointing the fingers at each other as to who owes what. Again, construction defect comes to mind, where you have continuing and progressive property damage over a number of period of years, different carriers, different defendants, and everyone's taking a different position as to who owes what. So you as the mediator, as Jean said, on one hand, you're trying to get your arms around the macro case, the case as a whole. But in order to settle the case, you're going to have to get the carrier to address, and all the parties to address, these coverage issues. And I'm the stick in the mud there, because I'm there to basically hold the line for my client, if that's what they want. And I'll talk about that in a second. So what are some approaches that you and us together can use to try to make our lives easier at a mediation? Well, let me start with what I view as the worst case scenario, which is that you as a mediator, you work all day, you work the rooms, you get the plaintiff to come down, finally get them down to a good number. The defense attorney has done a great job whacking away at the liability and damages, and you finally get to a good number. So at the end of the day, 4 o'clock, 4:30, the mediator says, okay, we can get this case settled. I'll just throw out a number, $200,000. And then I step in and say, great, that's a fantastic number, but my client, the carrier, we're only going to pay 50, and the insured is either doesn't have any money, or they believe that the insurance company should be paying all of it. So the bottom line is, you can't fund this great settlement that you just worked most of the day to get. That's what you don't want to happen, and because that's a waste of everyone's time and money. So how do we avoid that? The first thing is, you as the mediator should find out early and often what the insurance landscape is. Is it going to take insurance money to settle this case? And if so, how much? What are the issues? Who are the players? Who do I need to speak with? As coverage counsel, when I get involved, I immediately reach out, assuming the client has approved it, to the mediator and say, hey, I'm going to be there. There are significant coverage issues. I want you to know ahead of time what those issues are. They may get, we're there in good faith. We're going to try to settle the case, but there are some roadblocks there in terms of coverage. And then hopefully I've engaged the mediator in advance as to what those coverage issues are, what the challenges are, and honestly, a frank discussion. I had an off the record, confidential communication with the mediator, and I've said the coverage issues aren't great. They're not that strong, but they're there. So kind of help the mediator pierce a little bit of it, rather than just sit there and say, we're not paying a dime, there's no coverage. So I think as much pre-mediation education and prep that you can do as a mediator with the coverage attorney is to your advantage, and will help towards a successful mediation, at least in the sense that you're not learning about the coverage issues at 4:30 on the day when you finally got a great number that should settle the case. From my perspective, I also I reach out to the insured. I make sure the insured understands that there are coverage issues that are going to come up at the mediation that may get in the way of a settlement, in the sense of the insurance company paying the whole thing. So I've tried to work out a pre-mediation arrangement with the insured, or at least an understanding as to what the issues are, so that we can be prepared. And you as a mediator, in the pre-mediation communications, may want to inquire of coverage counsel. Are they doing that? Where does that stand? Can I assist in that if that's appropriate? Again, with the goal being to come to the mediation, even if it's an agreement to disagree, that's okay, because sometimes you can't agree. But at least everything's out on the table and it's been flushed out, and you don't wait till 4:30 to find out as a surprise the case can't be settled. I had a case where we worked for weeks before mediation with the insured's coverage counsel, and we did have an allocation and agreement as to how the case would be paid, because there were a lot of non-covered damages. And it was great because they ultimately thanked me for even being willing to put in some money, and I was thankful for them for acknowledging that there was little coverage. We got to the mediation, we sat in the same room, and we strategized together, focused solely on getting the numbers to a reasonable amount that we could settle within our agreement. So that was a great mediation because of the prep that had been done beforehand. I also obviously have a heart-to-heart with my own client, the insurance adjuster, and to make sure that they understand that we were there to settle the case, yes, and we're there to advocate our position, but we have to look frankly at the strengths and the risks and the cost of settling versus not settling. So that's part of our pre-mediation strategy. I need, as coverage counsel, to know what the expectations are of me. Is it to be a zealous advocate and draw a line in the sand as to what will be paid and not paid, or is it to be a facilitator with the mediator and try to get the case settled and be creative, think out of the box? And I've had mediations where I've shuttled around as much as the mediator has between the different rooms, trying to get money here and there and trying to explain what the challenges are with coverage, and then working with the mediator really to try to get money together. So I need to know my role from the carrier's perspective. I've had one mediator tell me that after we had our pre-mediation discussion, she said to me, please don't treat this as a motion for summary judgment. This is not your day to come into court and argue your case and then fold your hands and say, we're not paying. That's not why we're here. So I have to know my role and act accordingly. So that's always, a little bit challenging for me, because I've got a carrier there who wants to know that their position is being protected. But at the same time, we're there to settle the case a lot of times. So, like they say, sometimes the best settlement is the ones where everyone goes home unhappy. And I've had plenty of times where we go in there with a very strong coverage position, and we're not going to pay more than X, and we end up paying more than X because at the end of the day, the mediator has let us know that the coverage issues maybe aren't as strong, or we learn facts at the mediation that have a bearing on what we thought going in. I also like to speak with the defense counsel to make sure that I understand what the universe of facts are. I certainly, for instance, in a construction defect case, I don't want to go in there guns a-blazing saying there was no damage to any property, only to have an expert pull out a binder of pictures of leaking windows and warped floors and damaged drywall, and I have to eat crow a little bit. So again, it all goes to the preparation, and you as the mediator, will want to make sure that this prep work is being done and that everyone understands the facts. There's been times too where the mediator has called me into a private meeting just with the plaintiff's attorney, and had the plaintiff's attorney sit down with me and say, you may think these are the facts, and based on those facts, there's little or no coverage. Maybe you didn't know this, and those facts may influence things.
Bryan, let me ask you a question, Bryan.
Yeah.
In my experience, a lot of coverage lawyers, people in your position, are reluctant to have one-on-one conversations with a third-party plaintiff, concerned that something will happen that will give rise to some kind of bad faith liability, or that there will be somehow subverting the policyholder's interest. What concerns have been raised when I personally think it can be very effective in mediations when coverage lawyers do that, engage in those direct communications with the plaintiffs. Are there obstacles to doing it? What makes it successful, and what are the obstacles to avoid?
Well, in terms of bad faith, you know, out in California, we have these things called white waivers, where anything that you talk about at the mediation, and there's also mediation privileges and stuff like that. So I'm usually not worried about, quote, bad faith during a mediation in terms of having frank discussions about coverage. In terms of meeting directly with the plaintiff, assuming I have a claims representative there who's there for the coverage issues, I will check with he or she to make sure that they're okay with me having this conversation. And of course, if the policyholder is there too, that would be my first thing. If the mediator comes to me and says, hey, the plaintiff's attorney wants to talk to you, he or she thinks that there's stuff you don't know, I'll check with my clients first and the policyholder, see if there's a problem. I would view that more as information gathering and fact finding rather than advocacy necessarily, unless sometimes plaintiff's attorneys are as well versed on coverage as coverage attorneys are, because they know that if they don't push the right buttons on coverage, they're not getting the insurance money. So there's a fellow who brings habitability cases dealing with mobile home parks around California. I don't know if I'm supposed to say names or not, but I have been in a room with him on multiple mediations where he knows as much coverage as I do. And not that I'm a guru, but I've been doing it since '93. And he's a plaintiff's attorney because he knows what buttons he needs to press and what levers he needs to pull to get money out of me. And so if Jeff, to answer your question, if the roadblock to getting a settlement done requires a direct communication between me and the plaintiff's attorney, which I can then bring back to the adjuster and say, you know what, there's something we should think about. I think that's fair game.
And Bryan, in the age of online mediation, you mentioned having representatives of the insurance company there. What does it mean to have them there in the age of online mediation? I know that sometimes, particularly if we're mediating on the West Coast, it's hard to get East Coast representatives of insurance companies physically to come to California or the West Coast for a mediation. It's a day to travel, a day to mediate, a day to get back. Are you finding more or somehow different participation by your clients in the age of online mediation?
Yeah, I am finding that, when the mediator or the other side says, we demand that a claims adjuster on the coverage issue be there at the mediation, this pre-COVID, I would often get pushback because, as you said, a lot of them are on the East Coast, and what they say to me is, "You're there, Bryan, to advocate our coverage positions. It's legal stuff that if you can call me if you need money, but the money's coming from a different adjuster. You don't need me there. You're there as our representative." And then because they don't want to travel. Some adjusters love traveling. Most don't. Most have families, and they just don't want to be away, especially in California where it's a full day both ways to travel, plus the day of the mediation, and you have to stay overnight in case the mediation goes late hours. So it's a 4-day. It could be a 4-day hit for a 1-day mediation. I have found that now that we're doing things virtually, that there's a lot less resistance because they don't have to leave their desk. They have them Zoom on in one corner, minimized, and they're working. And if they need me to bark at them about coverage stuff, they go over to the Zoom part of their screen. So I have found more willingness to participate because the travel part is done.
And has that made it easier to settle cases? Does it have a positive impact on third-party plaintiffs, knowing that there's more consistent or more time being put in, even if it's only partial attention by people from the insurance company?
Yeah, I haven't done a metric on that. I don't think, so far since March of COVID, that it's made a big difference one way or the other, the presence or lack of presence on a Zoom mediation of an adjuster. We're still dealing with the same, coverage issues, whether he or she is there or not. So I can't say that that's made a big difference.
Okay.
So, see, I want to leave time for Gene, so I'm going to wrap this up in about 3 or 4 minutes. That's okay, Gene. And then, so one of the other issues I want to address was about the process and the dynamics. Who sits where? A lot of that depends on the dynamics of the mediation, the pre-mediation discussions. So in that one case where I mentioned where we had an agreement going in, it was easy. We sat in the same room and we strategized together on settling the case. There's been other times where I check in and the receptionist says, okay, you're in room 3. And I sit there in room 3 by myself for 8 hours. And the mediator might come in at the beginning and ask, and just, certainly if we've had a pre-mediation discussion, it's a shorter conversation, but if not, to get a lay of the land about what my position is. And I might say, we're here. We don't think there's coverage. I got $15,000, $20,000 sweeten the pot type of money. And then I sit there for 8 hours, and then Jeff comes in at 4:30 and says, all right, I got a number. You're sweetening the pot money. Can you sweeten it a little more? And I call and invariably I usually do. So that's one level of participation. And like I said at the beginning, there's other times where I'm really the one driving the train, because if it's going to take $200,000 to settle, and all of that needs to come from me because either the insured won't or can't pay, and someone's got to crack open my coverage stuff, then I'm the star player. And not only am I sitting by myself, but I'm working the rooms, like I said. So my participation varies depending on what the dynamics are. But I've played all the roles in over the years. There's also been a question asked about who should be there, and in terms of the adjusters. Who, as a mediator, do you want there from the company's standpoint? And the quick answer is whoever's writing the check, who has the checkbook. Because a lot of carriers, when there are coverage issues, they'll split what they call split the file. So you have one adjuster who is operating blind to any of the coverage issues. He or she is just adjusting the case, assessing liability and damages, getting their arms around, how they can assess the value of the case. They're not concerned about coverage. And then you have a different person who I interface with, who's the coverage adjuster. And their job is to say, okay, great, so the case is worth X, but this is what we're going to actually pay, if at all, because of the coverage issues. So they have two adjusters. Who do you want there? And you want to find out ahead of time who do they have to convince? Who do you have to go to say, this is what I need and why? Again, nothing's more frustrating than going through all day and then coming to me and saying, I need $65,000. I know you said you had 20, and then I have to, now it's 5 o'clock, my adjuster's on the East Coast, it's 8 o'clock, and I have a cell phone number, I can't get a hold of that person. So if the coverage adjuster is the one that has to make the final call, that's who you want. And if it's the liability and damages adjuster, that's who you want. But make sure that there's a clear understanding ahead of time who's going to be there so that you know who to go to for the check. And the last thing I'll mention is settling. When you finally get down to 4:30, 5 o'clock, and you have a settlement offer, my role, that's when I get paid the big bucks, as they say. There's my cat. That's where it gets challenging for me, because in California and most states, you have a duty to settle the case and get your insureds out of harm's way if the settlement number is reasonable, and in theory, you're not even supposed to consider coverage issues. So it's challenging for me when you as a mediator come to me and say, this is a great number, you should settle the case, and then my client, the claims representative, says, we're not paying it. that's harder than a situation where the number just is ridiculous. It doesn't matter coverage or no coverage. It's not going to settle. So, you know, when you come to me, when you come to me with a good number that should settle the case, you know, that's where I have to talk to my carrier about different options. It may be a policy release where they say, we're not going to pay this, but we're going to give the insured some money, let them do what they want with it, and we'll get a claims release for this claim. We're done. We've at least resolved that. We're done. We can, although carriers don't like to do this, they can do what they call a Blue Ridge settlement, where they pay and they reserve their rights to seek reimbursement of that settlement from the insured. They have to use some magic words to trigger that. So there are some options, but it is challenging for me as a coverage attorney when there's a good number that should settle the case and coverage issues stand in the way of consummating the settlement. That tends to keep me up at night, and that's 9 times out of 10 the carriers I have seen will err towards the side of settling the case if the numbers are reasonable. They're not gonna go overboard. So those are some of the issues that I see as coverage counsel attending mediations. I have a question in the chat which I'll respond to privately, and then Gene, I'll turn it back over to you.
Brian, let me ask you one more question. You made
Sure.
a very interesting comment about your own function, working the rooms and talking to people. In the good old days, let's call that 2019, when we were all physically together in one suite of offices someplace, you could kind of orchestrate seeing somebody in the coffee room or the kitchen or walking in the corridor. Now in the online environment, it's the mediator who has control over which breakout rooms people are in, and you can't really move yourself around, and you can't have those kinds of casual, supposedly coincidental interactions that you had when we were in person. So what are you doing? Are you texting people? Are you calling them? Are you emailing them behind the scenes? What are you doing?
Texting.
You're texting.
Texting. Gene, I don't know if Gene will weigh in on this, but the last mediation I had, the mediator gave us her cell phone number, and she was texting us. She said, "I'm coming to your room in 2 minutes."
Uh-huh.
You know, and so in our breakout room, you know, I would tell everyone, okay, put your work down, mediator's coming. Conversely, I would be texting her saying, hey, when you have a chance, and she called me. We actually had a call, you know, because it's just easier to do that than through the chat function. But we could also use the chat function to send a private chat to the mediator saying, hey, we got to talk. So it's the chat and the text.
And are you doing that as well with the other lawyers who were involved in the mediation, as if you were walking down the corridor?
Even at an in-person mediation, I was hesitant to just take it upon myself to speak with opposing counsel. I mean, that's why the mediator, that hasn't really, I might say, you know, the mediator might invite me to do that, or I might ask the mediator, hey, let me just do this one-to-one because there's a misunderstanding here. And that hasn't changed with Zoom, you know, virtual mediations. I would still say to the mediator, hey, check with the plaintiff's counsel, see if it's okay if we have a private breakout room call or text, whatever. So that hasn't changed. It creates more challenges because it's not as easy, like you said, just to walk down to room 2, knock on the door and say, hey, can we talk for a second? But instead of knocking on the door, you send a text. So you just make sure, you know, as mediators, that all is organized in advance, that everyone knows the rules of the games in terms of chat rooms, breakout rooms, texting, calling on cell phones and stuff like that, so that you're not scrambling trying to figure out how to work this.
Got it. Thank you.
Hello. Well, thank you, Brian. As Brian said, we worked together from 1993 until I retired from the firm the end of 2016. So we have a long history together of these things. And can probably speak over each other, just know exactly what the other one would say about things. So, thank you, Bryan. That was great. A couple of things to follow up on to get started with what Bryan was saying is, you know, in terms of who's in the room, if there are coverage issues in a case, or if coverage has been denied for a particular set of damages, because coverage means indemnity, and there's a duty to indemnify and a duty to defend. Well, it's the duty to indemnify that is the settlement part of it. And so a carrier insurer may be defending the insured, but has already told the insured maybe from the beginning, I'm sorry, these fraud damages are not covered and we're not going to pay for fraud damages or punitive damages or some other kinds of damages. Your policy does not provide coverage for those. And so then you know, as opposed to factual things that would play into, you know, did this loss happen during the policy period or not, you know, kind of thing. That's more of a factual thing. But anyway, so at the mediation, you will oftentimes have a policyholder coverage counsel as well as the insurer coverage counsel. And most defense counsel, especially if it's an assigned panel law firm that's defending the insured in the case, you know, they will have advised the their client, the insured, to go get personal counsel and to go get somebody who knows insurance, because they can't deal with it. They can't address it. The tripartite relationship in California and in other states that have it preclude the defense counsel from talking coverage at all with their client, because they represent the insurer, they represent their client, and then themselves. The three of them are in the tripartite relationship, whereas the coverage counsel is not part of that tripartite relationship. And it might be not coverage counsel, but monitoring counsel. You know, the London insurers may send a U.S. lawyer. Oftentimes they are coverage oriented, but a U.S. lawyer of any kind, whatever their background might be, to a mediation to monitor it and report back and basically stand in their shoes. So what you will get in these claims and these mediations where there are coverage issues or there is no coverage for something in particular, you know, you have the defense counsel, you may have their coverage counsel, you may have the coverage adjuster, the claims professional, you'll have the claims professional for the case itself. So there could be at least 4 people on that one side, maybe more, depending on, you know, what's going on. And that could be for every defendant too, if there are multiple defendants. And if there are multiple insurers, you could have multiple coverage counsel, multiple defense counsel, multiple claims representatives. It can get quite large. From the plaintiff side, as many of you know, you end up with the plaintiff attorney, and oftentimes you will have a plaintiff, you know, coverage counsel as well for the policyholder coverage counsel. And so you really have it at the end of the day for a settlement. You may have multiple settlement agreements in place that need to be finalized, or that the counsel are finalizing, not that you're finalizing, of course, but the counsel are finalizing. You know, the plaintiff and defendant one that you're, you know, that's being documented that you've negotiated. And then if the insured has agreed to put in money and reach an agreement with its insurer, for example, then you would have that type of agreement of some sort. You may have multiple insurer agreements as between themselves. Maybe they're going to pay and then go back and do a declaratory relief action to reallocate if somebody feels that they aren't putting in, you know, they're putting in too much, someone else isn't putting in enough. You may have an agreement where the, like Bryan was talking about, the Blue Ridge settlement kind of thing, where the insured says, I'm sorry, no money, and we dispute the coverage denial, and we think that these damages are covered, and the insurer decides to go ahead and pay the damages subject to reservation of rights to recoup whatever the non-covered damages would be. So really, it can get to be quite large. And Jeff's comment asking about the dynamics of that, are very interesting. One thing I found in this well, not post-COVID really, post good old days and during this COVID time, is the a change to do mediations on multiple days or phase the mediations more, which is actually quite wonderful. I mean, it was done before, but it's, I think, even done more now, where you would maybe get multiple carriers together with a mediator, and in anticipation of going to, for example, the the habitability mediation that Bryan mentioned, figure out what they're going to do. And then another aspect of it would be mediating between the insured and the insurers, so that you know what they're going to pay. And then they reach a memorandum of understanding or an agreement or something. It could even be as extensive as an insured and an insurer, especially if they're corporate insureds, sitting down with their general counsel and the head of claims to figure out, okay, here's what we've got. What are we going to do about this? And then working out a roadmap for what will be paid, what won't be paid, who's going to go back after whom, these kinds of things. 1994 Northridge earthquake, there was a major case that involved that. Justice Cheney, she's in the second appellate district here in Los Angeles now. She told me once how she had learned coverage off of this one particular case. Well, not learned it really, but that's all. It could have been a law school class, this whole case, for all the many issues that there were. And she was our judge, and we really appreciated that at the time. So that would be that. I do think that there's such value in those pre-mediation conference calls that we as mediators conduct, and to find out, what people are thinking or doing, and where are the buttons that I need to not push in a bad way, but who's got the checkbook, and what are the issues, and who's who. As Bryan, was saying how he goes and he may sit for the day with, never being talked to until the end of the day. Yeah, sure, I did that many times as well. But there were many times when really I was the one, and I wasn't party counsel. Where your monitoring counsel or your coverage counsel may in fact be the one that is the one who the mediator really needs to key in on, because they ultimately are dealing with the claims representative who has the money or not, and has the pulse of everything. And I would just say as mediators not to give up on these cases. They can be difficult. They can be very challenging. Maybe challenging is a better word than difficult, just challenging. It's the reality. It is what it is. And how you can find resolution is not in the same way that you can in a simple two-party case with no coverage issues. I know, Chuck, you asked a question here. Are there types of cases in which you believe co-mediation may offer worthwhile advantages and benefits? Yes, exactly what I'm talking about here. If you're not going to do, the parties aren't going to do some advanced mediation of these other issues to prepare for the main mediation, certainly there can be value in having multiple mediators, two mediators co-mediate a case. Insurance issues would be one like what we're talking about, along with someone with the factual issues. Construction defect, I've seen it. Habitability, I've seen the thing. Big cases where there are significant coverage issues. Huge construction defect cases. There are a lot of different types of cases. And again, we're talking in the commercial and civil arena. In general, I think it's so important to have the mediator focus on, first of all, tangible. Make sure everybody's clear on the facts and the issues, because then you can deal with the intangible, any feelings or emotions. And it's it's not like a car crash case where you have personal injuries, but emotion is a driver. And even in these commercial cases that you would think it might not be. And, I've learned early on not to underestimate that, both in practice and as a mediator now. Somebody's got, like in an IP case, that was their baby, that business, or in any case, if you have a business owner, that was their business, their baby. They sacrificed to build that business. They went without probably to build it, or it reflects their creativity. And to now have something else come up where somebody's using their designs, if it's an IP type of case, or they're, taking their whatever, their product, their thoughts and turning it into something else. Or competition, unfair competition kinds of things, it can be hard. But ultimately, I think that in these cases where there is either no coverage or certain damages are not covered and some are, you really, as a mediator, need to, and as a practitioner, as an advocate, need to be prepared that the mediation in some form or fashion has to, and by necessity, includes the mediating the coverage case within the liability case to achieve a global settlement. And, in other words, to facilitate resolution of everything. And it may be more than you bargained for if you don't have the advanced preparation like Bryan was talking about and you're suddenly surprised. So, I put it on us, the mediators, to understand what's coming in the next day or the next week or the next month, and encourage the parties to do the necessary work in advance so that they can have a successful mediation. And success, of course, as we all know, can take many forms. Maybe it means the case is actually settled and concluded and dismissed, the main case, and that all the issues, the extraneous issues, are resolved. Maybe it means the main case is settled, but the insurers and insured or whoever, all these extraneous parties, are going to move on and adjudicate their issues in a separate lawsuit. Maybe it just means that they've learned about more information and they need to regroup and evaluate that and then come back for another session down the road. Maybe they need to do some discovery first. Maybe somebody needs a summary judgment motion. That's one thing to keep in mind. A lot of these cases, if they involve the coverage issues or indemnity issues, those are legal issues a lot of times. Most of the time, they're not factual issues. And so a summary judgment motion may very well be pending during the mediation time period, may have been chosen specifically for that purpose, the timing of it. But it may be too that once there's better clarity on the legal determinations after a summary judgment motion or something, then it would be a better time to regroup, revisit, reconvene, if in fact you haven't been able to get it all settled that day. So I don't know, do we have questions or any other thoughts? Let's see here. Who do we have in the, Jeff, are you going to take to go through the questions here, or is that Natalie?
Yeah, let's take a look and see what's going on in the chat. Looks like Bryan answered a question. So many times I find as a mediator that the lawyers representing the insurance companies are very protective of their clients and don't want the mediator speaking directly to the adjusters. What is your sense of that? Why do you agree that lawyers tend to be highly protective in this context? Is it a good thing, a bad thing? What should mediators know about those attitudes?
As a mediator, I haven't really found that to be the case. I think a lot of it depends on the personality of the claims professional. Some of them want to get in there and talk, and they know their cases. Believe me, do not underestimate an insurance claim professional. There are, of course, extremes on both sides, but generally they know their cases, they know it inside and out, they've roundtabled it, they've gotten input from you know, management, or at least their management. And so they're coming in prepared. So I haven't found that to be the case. Brian?
And Jeff, more and more, I'm coming to these mediations with a coverage adjuster who themselves is a practicing attorney, and they just went in-house. And I'm finding more and more that my clients are attorneys, and it's a different level of conversation, frankly, to have about the coverage stuff, because it's not they're not a potted plant who's just relying on me to further their position. Sometimes I'm the potted plant, and they're the ones that are very aggressive and really want their voice to be heard. So like Jean said, I have not had a situation where they've balked at speaking to a mediator. Again, it's, you know, most mediators I have found ask for permission before just saying, I want to talk to you. You know, they'll say, is it okay if I speak to you and the adjuster privately? You know, so, you know, just get the ground rules, get the permission, get the consent, and it's usually all good.
Is it the case, Brian, that there are times when you come to the mediation not really knowing what the level of authority is, and that it's really as the day goes on, the adjuster's role becomes more prominent for that reason?
I usually, no, I mean, I can't think of a time where I went to a mediation and had no idea what kind of money I had to spend, you know. That said, there's certainly been times where the money that they thought they were going to pay and not a penny more was a couple pennies more because of how the dynamics unfolded at the mediation. You know, like I said, if there's a settlement number that comes around that really should settle the case, my experience has been that the carriers, they're not going to pay all of it and just give up all their coverage positions, but they know that there's a risk and a cost of letting a good settlement go by the wayside because they stood on a coverage position. So I might have authority, but a lot of times it does settle past that authority, just as it does from a liability and damages adjuster standpoint. But I do usually have a framework to work within in terms of dollars. It's very rare that I get sent to a mediation and my marching orders are to sit there with my arms crossed, briefcase closed, keep my jacket on, and say, we're not paying, there's no coverage. Why go? You know?
You know, one thing on that too is the, oh gosh, now I was reading this question here. So the other thing, skipped my mind here. I'll keep going, it'll come back to me, sorry.
Well, Jean, if you've noted Chuck's question in the text box there, chat box, if you want to comment on that, that's fine.
Sure, and that actually brought back what I was thinking of before I started reading his question. You know, lots of times a good tactic for the mediators, if you get to the end of the day, and I'm sure you all do this probably, but one thing I found helpful, you know, a lot of times people in general, but also the claims professional or the general counsel, the risk manager, whoever it is that's calling the shots, they need what I call time to sleep on it. What it means to me for a business though is, you know, they need to take it back maybe to other people. Maybe they need to roundtable it. Maybe they need to think about it. So I like to leave people with something when they leave. You know, okay, let's hold that offer open, you know, until the close of business, you know, on Friday or for a week, you know, whatever it is, so that the people involved in these commercial things can have the time to see if they can do it, or even then do the telephonic negotiations during that time. If they say, look, we can't go to X, but how about if we do Y, you know, that kind of thing. So that's one strategy. Although Chuck's question here is, Jean and Brian, do you have strategies that you consider effective for dealing with parties or counsel who engage in quote unquote gaming or abuse of an imbalance of power and leverage. You know, I just tend to treat everybody as professionals, and I guess I can't even think of a specific strategy other than, you know, dealing with it as it comes in a professional manner. Bryan, do you have thoughts?
Yeah, I think that that kind of gaming, posturing is counterproductive. I know that a lot, there's some attorneys out there who feel like that the only way to get the attention of the carriers is to start screaming bad faith and we're gonna do this, that, and the other thing to you. And I usually let the mediator know that to pass the message on that my client's not going to settle a case or move its position based on being bullied or yelled at or screamed at. That we're here to talk about the case intelligently and reasonably, and that bullying tactics aren't going to work, and kind of move them off that mindset. Because unfortunately, I've dealt with too many attorneys who that's how they go through life, I guess, is feeling like they always have to have the upper hand and get things done by screaming and yelling. And I like to let them know that may work in other parts of life, but it's not going to get the case settled today.
Yeah, that's a good point. And that, oftentimes when I have, as a mediator, when I have the parties there and someone is, bad mouthing the other side for whatever reason, I have done several things. One is, in fact, I did this yesterday in a mediation. I was like, okay, let's finish venting. Is there anything else that you want to vent? Let's just get it out on the table and then we'll move forward, with the focusing on the facts and the issues and the negotiations. And usually that triggers a little bit of a laugh, but it probably also means they vent some more, for whatever their thoughts are that they came in with. And that's fine. I'd rather get the emotion and the venting, out in the beginning and then try and manage it as we go through. And then I also, as a mediator, will try and bring people back to the reality, back to focus on what we're doing and why we're here. And then, of course, I'm sure you all do this too as mediators, and what comes down the pike, i.e. trial or more expense, etc., if you don't settle this case today. And, so let's give it our best. That's why we're here, blah, 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 that type of thing.
Yeah, I'll just a quick war story on that. I'll never forget there was an opening session in a construction defect case where the mediator thought it was a good idea to have everyone in a big room, and he gave the plaintiff's attorney an opportunity to do a dog and pony PowerPoint slideshow about what the damages were at this property, and ostensibly to educate us. So this attorney went ahead and did that, and then because there had been some prior settlement discussions and some prior motion practice and stuff like that, and then he immediately during the course of doing this slideshow thing, he turns to the room and he says, because the insurance company in bad faith failed to settle this case when it could have and should have, that's why we're here today. And said, we're going to come after them for punitive damages and blah, blah, blah. And, I'm sitting there with a claims examiner and we're both blowing smoke out of our ears. And it took 2 hours to get everyone back to ground zero because of that inflammatory presentation. And because it immediately, put us on the heels of saying, if this is how we're going to operate, we're not here to settle the case. We're here to equally, be belligerent. So just something to keep in mind in terms of opening sessions and where you want that to go.
Okay, it is 9 o'clock and it's time for us to conclude. Jean, thank you very much. Bryan, thank you very much. Natalie, as always, $62,400 raised so far. We have please support Homeboy Industries and the Alameda County Community Food Bank if you are in a position to do so. We wish everybody happy Hanukkah, which starts tonight. And with that, I believe we are complete. Thank you.
Thanks, everyone.
Thank you, everyone.
Thanks.
Bye.